How to file divorce petition by mutual consent. The provisions relating to divorce by mutual consent describes under section 13B of the Hindu Marriage Act 1955 and under section 28 of the Special Marriage Act and under section 10A of the Divorce Act 1869. The Hindu Marriage Act applies to those belonging to Hindu, Sikhs, Jain and Buddhist religions. And Special Marriage Act applies to those couples who have applied for court marriage or who belonging from different religion. And Divorce Act applies to those belonging from Christian religion. And Muslim Marriage Act 1939 governs the laws who applied for marriage and divorce of the Muslims. The petition for dissolution of the marriage by decree of divorce by mutual consent may be presented to the district court before the principal judge of the family court by husband and wife jointly on the ground that they have been living separately for a period of 1 year or more and that they have not able to live together and that they agreed that the marriage should be dissolved. The entire process of taking divorce by mutual consent will completed in two stages. First stage is called the first motion and second stage is called the second motion. Now the jurisdiction where the divorce petition can be filed. Divorce petition can be filed first where both the petitioners lastly resides as husband and wife, or second where the marriage took place, or third where the wife is residing. First, husband and wife jointly file a petition under section 13V clause 1 of the Hindu Marriage Act before the principal judge of the family court in the competent jurisdiction, and this is called the first motion petition. And on the date fixed, both the petitioner appear before the court for recording their statement, and the court, after examining the petition and the documents, pass an order. In this way, the first motion has completed. Now the documents which required for filing the first motion petition. Delhi district courts. First, case information format duly filled. Index, memo of parties, court fees ₹15. Petition with supporting affidavit. Affidavit of both the petitioners as per judgment dated 15th May 2018 passed by the Honorable High Court in the case titled Rajat Gupta versus Rupali Gupta. Passport size photographs of both the petitioners is required to be affixed on the petition with cross-signed. Mobile number and age of both the petitioners also mentioned on the petition. Police station jurisdiction bias mentioned on the petition, and marriage proof in original. Marriage proof in original is to be required anyone, that is marriage photo, marriage card or marriage registration certificate or certified copy of the marriage in original. If the marriage proof is not available by any chance, the affidavit for non-availability of the marriage proof by both the petitioners is required to be filed. Aadhaar card of both the petitioners is mandatory to be filed. If Aadhaar card is not available, then affidavit is in his support is required to be filed with any one photo ID proof, that is voter ID card driving license, passport, or valid rent agreement. If Aadhaar card is available but the address of the parties are different, then the copy of the Aadhaar card which is available with any other photo ID proof with complete address, that is voter ID card, driving license, or passport, and valid rent agreement of the photos of the tenant and landlord with complete address as per petition or as per jurisdiction is required. Vakalatnama of both the petitioners, advocates. Affix court fee of rupees 2 and advocate bail fare ticket of rupees 25. Extra one complete set of petition with documents will annexed in this petition. After completion of the first motion, the husband and wife jointly file a petition under section 13V clause 2 of the Hindu Marriage Act before the principal judge of the family court, but not earlier than the 6 months after the presentation of the petition for first motion as referred in subsection 1, and not later than 18 months on the said date if the petition is not withdrawn in the meantime. After completion of the first motion, a minimum waiting period of 6 months, that is called the cooling period, is given before filing of the second motion, and this period is given to the couples as for reconsider their decision. Now the main point is that the second motion can be filed only after the 6 months on the date of the presentation of the petition for first motion, not on the date of the passing on the order of the first motion. After passing of the minimum waiting period of 6 months, both the husband and wife again file a petition before the principal judge, district court, and on the date fixed appear before the court, and the court, after examine the petition and documents and satisfy itself that both the petitioners have settled all their disputes relating to the alimony, custody of child, maintenance, property, and such other things, and that there remains no disagreement between the parties, and the Honorable Court pass a decree by declaring the marriage to be dissolved with effect from the date of the decree. Now the documents which required for filing with second motion petition in Delhi are case information format duly filled, index, memo of parties, court fee of rupees 15, petition with supporting affidavit, passport size photographs of both the petitioner to be affixed on petition with cross signed, mobile number and age of the petitioners mentioned on the petition, police station also mentioned as per jurisdiction wise, marriage proof in original to be filed, that is marriage card, marriage photo, or marriage registration certificate or certified copy of the marriage proof in original. If marriage proof is not available, an affidavit for non-availability of the marriage proof by both the petitioners to be filed. If 6 months is not completed and the second motion petition filed before the 6 months of the filing of the first motion petition, then an waiver application under section 151 of the CPC is required to be filed by both the petitioners, and the supporting affidavit is to be filed by both the petitioners along with that. certified copy of the first motion, including the order, judgment, and statement of the both the petitioners, is required to be filed. Aadhaar card of both the petitioners is mandatory to be filed. If Aadhaar card is not available, then affidavit is in support is required to be filed with any other ID proof with complete address, that is voter ID card, driving license, passport, or valid rent agreement with complete address. The Aadhaar card is available, but the address of the both the parties is not correct. Then the copy of the Aadhaar card which is available with another photo ID proof with complete address, that is voter ID card, driving license, or passport, or valid rent agreement with photos of the tenant and landlords with complete address as per petition is required. Next, Wakalatnama of both the petitioners' advocates is required to be filed. Court fee of ₹2 affix on the Wakalatnama, and advocate bail fare ticket of ₹25 also affix on Wakalatnama. One extra photocopy set with documents is required to be annexed in the second motion petition. Please note that if the case belongs to Special Marriage Act or Indian Divorce Act, then original marriage registration certificate is required to be filed. And if the case belongs to the Muslim laws, then copy of the Nikah Nama with translate in English only is required to be filed. Now the 2 points should be keep in mind before filing the petition of divorce by mutual consent. First, the divorce by mutual consent can be filed after the separation of the parties 1 year. Second, the second motion petition can be filed after the minimum waiting period of 6 months from the date of the filing of the first motion petition, not on the date of the order of the first motion petition. But the separation period is 2 years in Indian Divorce Act 1869.